All right, I think we're going to get started. Welcome, everybody. I'm Allison Warren. I'm Assistant Dean for Experiential Education at UCLA School of Law. And again, really like to welcome you to the first session in our Teaching Justice webinar series for the 2021-22 school year. And today we are excited to present Teaching Justice through Teaching Ethics. Our fabulous guest today is Gautam Hans from Vanderbilt Law School.
And I am Layla Halas. I'm the co-director of the Immigrant Rights Clinic at Tulane. I'm also the Associate Provost for International Affairs at Tulane. And we are also just kind of introducing you to the whole series, the Teaching Justice webinar series, which is a project of CLEA's Best Practices Committee, which has featured a number of innovative faculty discussing new approaches to teaching justice in the classroom. Each session focuses on how the wisdom of current social movements can be incorporated and examines intersection within criminal justice, immigration policy, racial justice, economic justice, among other issues such as today's topic of ethics. We have a really amazing lineup this year. So we hope you stay tuned for our next in the series and the year. Check out the CLEA website as well as clinic and Lextern listservs for more updates and information.
And you have undoubtedly seen already that this session is going to be recorded. It will be made available later on the CLEA website, and we'll circulate that information and the link after the session concludes. Gautam has posed a couple of questions through the poll function, which we'll be launching shortly. So please do complete it. And in addition, please use the chat function to let us know what types of ethical issues you might cover in your clinic or externship seminar. If you have a question during the session, we encourage you to use the chat function to raise it in real time. We do ask everybody to please mute their microphones, but if you're comfortable, you're welcome to keep your video on during the session. And with that, take it away.
Hi, everyone. It's great to see so many folks joining during what is for me the lunch hour on Central Time. I'm really happy to be the first person in the Teaching Justice series this year. It's a great series. I'm also happy to be the token man in this series because I see that we have an incredibly diverse and lineup coming up with a lot of really great people. So I am happy to go first because they're going to do better than me, and then I don't have to worry about matching the brilliance of my colleague Carla McCanders or Robert Marco Sterling, et cetera. So really excited to be here. I'm also excited to see friends and only a few enemies on our attendee list today. So I think this will be a great discussion. So with that, so Layla had posted in the chat question that is open-ended if people want to talk a little bit about what in the chat what ethical issues they cover in their seminar. But I do have a couple more targeted questions in the poll function that I think my wonderful assistants will set up. So please do answer those questions so we can get a sense of what's happening in our group today. So we see, first of all, about the usual response rate that I get when I do polls in my ethics class, about close to 90%, which is great. Almost everyone does cover ethics. We have a 95% rate of people saying yes in their seminar and 5% say no. But of that, we have a little bit of a distribution where some people, less than 10%, 8% say a lot, in terms of how much time they devote to teaching ethics. Most of us, about 2/3, 68% saying some, and then about 20% saying a little, and then a few people saying none, of course, the people who don't do it this way. So what we're going to do today, I'll tell you a little bit about sort of how I come to think about this, how I came to thinking about this topic, and sort of my own process and strife in thinking about teaching ethics and teaching the clinic seminar. So I came to Vanderbilt, this is my 4th year, having done a teaching fellowship at the University of Michigan Law School, where I also had been a law student. At the time, and I think still to this day, taking clinic as a law student in Michigan almost certainly satisfied the professional responsibility requirement for graduation, which is an ABA requirement that students have to take some course that's devoted to ethics. Those of you who teach in New York have a more specific requirement that postdated my time in law school, in which the class really has to be focused on ethics in order to satisfy the New York bar. So the clinic seminar, based on my understanding, didn't satisfy that requirement when I was a law student and when I was a fellow. So theoretically, at least in the 7-credit clinic that I co-taught with Dana Thompson at Michigan as a fellow, we talked about ethics. And I think, for obvious reasons, it's hard to think about teaching clinic without thinking about ethical considerations coming into play. And so at Vanderbilt, we have 4-credit clinics, and all of the clinical faculty teach 1 class per year in addition to their clinical load. And so when I was interviewing for the job, I was asked, what would you be interested in teaching? And like any good interviewee, I was like, I'll be whatever girl you want me to be. I'll teach First Amendment if you want. I'll teach a First Amendment seminar, or like a law and tech seminar. And I said, oh, and I can teach ethics too, because we cover it in clinic. And they had a need, and they were like, yes, teach ethics. That will be very helpful for you if you say that. And so I told everyone I would. Even though I never had taken legal ethics as a student, even though I had barely passed the MPRE, even though as a clinical fellow, I didn't feel like I was necessarily expert in ethics. And so, as with everything in my life, I'm like, well, we're just going to do this and we'll see how it goes. So, practicing clinical pedagogy as a clinical faculty member, sort of being thrown in the pool myself. And so I have now taught ethics. This is my 4th year doing it. I teach it in the fall. I've done it in a couple different ways. The current version I teach is a limited enrollment 30-person lecture class with a lot of participation. I use the textbook that Lerman, Schrag, and Rubinson have, all I think known to many of us as clinical faculty, which is very focused on problems, less so on the rules. And I supplement my class with a lot of secondary source articles. So for example, today we were talking about legal ethics for government attorneys and judges. Some of you may have seen the Wall Street Journal article from a few days ago about the judges, I think it was 130, who had failed to disclose their sort of stock ownership. And so we talked a little bit about, the judicial system and why there might be so much rampant lack of compliance by some of our judges and the issues with the Supreme Court not having their own ethics. So in addition to talking about the rules, we talk more generally about dynamics within the profession. So I'm of the opinion, as a relatively new ethics teacher, I've been radicalized into thinking that it's the most important class in the curriculum. But why is that? I think because ethics as a class allows for students to understand that lawyering is not easy, right? That it's not just about the doctrine. It's a lot about what we teach in clinic and externship about working with our clients, how ethics are always coming up in practice. I sometimes tell my students then when I was in a few years ago, we had a 1.7 conflict of interest issue that totally was not foreseen, and the students had to work through it and figure out how to analyze the problem. So it's something that even if you might not think is going to come up in your practice, it invariably does. The profession and the rules are not going to give you a lot of guidance. So anyone who teaches ethics or who has spent time thinking about what it means to be an ethical attorney and looking at the model rules, you'll see that the model rules are not going to get you very far in figuring out how to be an ethical attorney. You have to sort of supplement that with your own personal guidance and personal sense of ethics, and as well as sort of the norms of the practice area you're in, the norms of your legal organization, of the jurisdiction that you're in as well. And that's sort of like part of what it means to be an ethical attorney in my mind. The rules are a necessary but insufficient condition in learning on how to be an ethical attorney. So in the clinic itself, I actively try to incorporate ethics by both talking about specific rules, but then more and connecting them to some of the lawyering concepts we talk about, client-centered lawyering, confidentiality, effective communication, how to evaluate non-legal concepts and think about that for our clinical work. And so that's sort of how I do it on the high level. I have on the first slide the poll questions that I've asked that hopefully, like I said, we talked through already. And then here are a list of the model rules that I assigned at the beginning of the semester for students to think about, to discuss in the clinic seminar. And I try to split them up over the first few seminar sessions that I do on interviewing, counseling, et cetera. So when we talk about, for example, counseling, we talk about 1.4, about communication. What does it mean to be an effective communicator? How does the sort of ethical rule help us, or maybe not help us very much in thinking about those dynamics? And thinking about how students will use ethical concepts as a framework for working on their legal matters, but one that's supplemented by the sort of skills reading and training that we do, as well as what happens to supervision, all the different pieces coming together with client work. So towards the back half of the semester, we transition away from talking about ethical rules and more about ethical concepts and sort of the issues that might arise in specific clinical settings that can help think about what it means to be an ethical attorney or what it means to be an effective attorney for your client. So if we think about ethics as a frame for understanding the attorney-client relationship, they also provide an opportunity for us to think about how we as lawyers relate to our clients. So ethical concepts like scope of representation, like diligence, like lawyer as counselor, can help us think about our client interactions and dynamics similarly to the ways in which client-centered lawyering or cross-cultural lawyering can provide their own lens into the relationship. And I think sort of helping students to theorize the lawyer-client interaction through a variety of different tools, through different lenses, can help them sort of understand how multifaceted this relationship is and how it's not just sitting down with a client and talking with them what their legal needs are. It could be more complicated, comprehensive, and potentially conflicting depending on what frame we're using. Are we thinking about this as an ethics problem? Are we thinking about this as a client-centered lawyering problem? And what might those distinctions mean? So one way in which I think about that is how in my clinic as a First Amendment clinic, we think about impact litigation and the ethical questions that arise there. And so in terms of ethical rules, 1.2 scope of representation and allocation of authority, as well as 2.1, the lawyer as counselor, I think are some of the rules that help guide what it means to be an effective impact litigator, but it doesn't necessarily give us all what we need. And so I transition from talking about ethical rules into secondary readings that talk a little bit about the ethics of impact work, or what that work looks like, and what students and what lawyers have to consider as impact litigators. So in my First Amendment clinic, we do both direct services work where, for example, we might be counseling a client with issues involving defamation concerns. We might be thinking about whether a client's concerned about government action if they're not getting a permit for their protest. But we might also think about broader impact cases. Let's say, we had a case against the jail that was not delivering my client's mail to the subscribers within the jail. And so there was sort of a goal of having a larger impact beyond just the individual sort of mail issues that the client was facing, but also potentially other publishers that were trying to get their mail to the people within the jail. Or, for example, thinking about Tennessee's recent anti-protest laws and that were enacted, and what impact cases we might bring, and who might the client be that could maybe get those laws overturned or at least narrowed. So what students often encounter in thinking about those kinds of broader impact cases is thinking through what it means to be an effective attorney, what it means to be a First Amendment attorney, and who we're helping. So one of the classic issues that we see with impact cases is whether the client individually that we have as the named plaintiff usually is actually the person that we're predominantly focused on helping, and whether we're thinking more broadly about legal principles and who is driving the representation. So if we're thinking about trying to invalidate, let's say, the anti-protest legislation, are we really concerned about the protester who was affected by some government action from police, or are we more concerned about the broader population of protesters that we might be concerned about as lawyers, as advocates? And what happens when, for example, the individual client might be best served, let's say, by a settlement in which the city doesn't, or the government doesn't contest the broader ability for enforcement actions in the future, right? So let's say we're just concerned, the individual client might be able to sort of evade some kind of civil liability or criminal liability, but the law might be enforced against a future client. What do we do in that situation, right? What does it mean for us as attorneys to think through our responsibilities to the client as opposed to the broader legal principle that we're trying to vindicate or the law that we're trying to maybe invalidate? And so this is where students, I think, start to have some questions about what it means to be a lawyer and what it means to be an ethical attorney in that setting, and whether their role on behalf of the client is really furthering some larger social policy goal, or if we only care about the individual client, and what does it even mean to make those kinds of determinations? So I'll give a couple examples of how this has arisen this semester. We were talking about attorney's fees. So I teach a unit on how justiciability, standing questions, mootness, as well as attorney's fees, because obviously money is the most important thing to all of us, right? How do we get paid? And I'm lucky to work in a setting in which attorney's fees are a possibility under the Fees Act. And so one of the students, we were talking about a hypothetical about environmental litigation. Let's say that you're trying to get EPA to protect some endangered species. I have to say that I know nothing about environmental law, except that I believe in it and think we should have more of it. And so I apologize if I'm butchering the doctrinal framework for how this would get litigated. But let's say that you file some case against EPA and you get some attorney's fees settlement. One of the students was like, well, what happens that money, right? Money is not fungible. Isn't that money just going to go away from some larger EPA policy that we might want to enact, and we're just getting money for our own coffers as attorneys? But what does that mean, for the environment as a whole, and should we be concerned about that? And so we had a discussion, right? I pushed back a little bit. I said, well, why do we care about that? Like, isn't it EPA's responsibility to not break the law? Like, why is it my problem or our problem as attorneys if they're not doing their job and didn't litigate the case properly or engage in some unlawful action? Yes, I would feel bad if that took away from other programs, but that, the incentive structure here is designed for us to get fees so that the agency or the government entity is acting more properly, more generally, as opposed to this specific case. Another situation happened where, the students were helping a client with some Public Records Act requests to a specific agency, and that there was a bit of a combative relationship between the agency and the client. And the students thought that the client was maybe not doing things the right way, right? And so they were concerned that the client's Public Records Act requests were gumming up the system, and this was an overworked department that maybe had more concerns. And I had to remind the students that, we represent the client here, right? We don't represent the government. Like, I don't care if they're not, if they're overworked and they're unhappy and they're under fire. Like, that's not my problem, that's their problem. And I think trying to get students to think beyond sort of balancing the individual client responsibilities with the larger goals is a really important frame for them to think about in terms of what it means to be an ethical attorney, a public interest attorney, a clinical attorney, a social justice attorney. Fundamentally, what we're trying to get is what we're doing as clients and as attorneys for our clients, and why, and what can ethics do to help us frame those dynamics, and what can they fail to do, right? Where are the gaps? Where's the lack of information or the lack of guidance that the ethical frame can provide? So here, it's some of the questions that I want students to think about in terms of going through the ethics of impact litigation. What does it mean for us to be an impact litigator in relationship to our clients? What's that role like? What does it mean for the individual client needs versus the broader social needs? Whether and how our work as impact litigators is furthering social justice goals. What are those goals? Are those goals agreed upon? Are they contested? Who sets up throughout those goals? Where can we understand where those goals are coming from? And thinking about what it means for us as attorneys to be effective, to be humble, to understand what it means to be part of a larger social system, a larger advocacy system, a larger social movement, potentially, depending on what kind of case we're working on. One thing that I think those of us who teach in experiential, and maybe also those of us who teach ethics, have to think about is how students can be socialized into thinking that lawyers are the solution to life's problems or to the world's problems or to this country's problems. And as someone who's constantly committed to self-negation and undermining my own credibility, I often tell my students that we have to be a little bit more critical of this idea of legal supremacy or of lawyers as the solvers of problems or the effective paths, the law being an effective path to addressing social issues. One of the things that when I teach some of these dynamics in legal ethics is, I ask students, like, when you think of Brown v. Board, do you think of who Brown was, or do you think of Thurgood Marshall? And I think a lot of students, have to sort of sit with that question and think a little bit critically about what that means when we think about a case like Brown versus Board through the lens of lawyers versus potentially through the lens of the students and through their parents, through their communities. And I think too that, as a public interest attorney and as a person who teaches legal ethics, we have some stories that we rely upon repeatedly that may be exceptional as opposed to standard, right? So when we think about the effectiveness of the courts, when we think about judicial review, when we think about protecting individual rights, we rely upon cases like Brown versus Board or Windsor or Obergefell. And those are, I think, important cases, but I think that they don't necessarily go to how the courts are potentially an obstacle, right, to social change, how judges and courts and the legal system uphold certain supremacies or uphold certain outdated power dynamics, and whether we as teachers are effectively communicating that kind of dynamic, because I think students are well aware of that in the sort of public discourse around the limits of law, the limits of courts more broadly. So I use a few readings, which I have on the next slide here, that get at some of these questions in different ways in order for students to be provoked into engaging critically about what it means to be an attorney, what it means to be an impact attorney, and what the legal system does or doesn't do for our clients. So I put the sites up if people want to take a look later at some of these pieces. Obviously, I find them all to be really valuable. Only one of them do I hate. I'll let you guess which one of that is. And I think that it helps students sort of have concrete examples about what it is that we're trying to talk about when we are talking about these ethical or social policy questions. I don't assign all of each of these readings because they're fairly long, and I think some of the selections are good as jumping off points. In my clinic seminar, we use the reading. I use a bit of a flipped model where I have the students do the readings, but we don't spend a lot of time covering them. That goes for both skills and for sort of more theoretical discussion questions like this, where I will give students set a series of prompts in order for them to think through what the readings have provoked in them in advance, as well as what we want to talk about in the class. And I sort of let the discussion go where it's going to go. In part because I teach on my own, I never have more than 8 students in the class, and so it's fairly easy to moderate the discussion. And students learn from my talkative nature that I want them to talk as well, because this is supposed to be a dynamic setting. So starting with Derek Bell, I think obviously this is a classic article, one that, in advance of the session, I reread all of these articles and I found them really generative. Again, for me, part of the reason I like assigning them is that every time I read them, I have sort of new responses and reactions. And so the Bell article is focusing on the desegregation litigation, some of the ethical questions. His is the article that most, I think, actively talks about ethical rules and thinking about the responsibility of the lawyer to the client and what the differing goals were in the school desegregation litigation questions and what that meant. And so it's nice to sort of have a really expert examination of ethical rules through this case lens or series of ongoing cases where he describes how the impact litigators were potentially having cross purposes in different school settings across the country when they were trying to force desegregation. And what those ethical questions mean when the goals of the client and the lawyer diverge, and what the responsibility is of the lawyers in that setting. The Powell memo, like I said, my enemy, my least favorite of these readings, but one that I think is really important for students to grapple with, is a memo that Lewis Powell wrote when he was still working with the Chamber of Commerce prior to his appointment to the Supreme Court in the early 70s. It just predates his appointment to the court. And so in that memo, he basically says that capitalism is under attack, that businesses have been on the sidelines, and businesses need to be more effective and more agile and more active in litigating cases in the courts and trying to uphold the free enterprise system in his frame. And so this is an important reading, I think, in part because it helps students understand that these tools are not sort of benign social progress, kumbaya tools. They can be tools used to reify corporate power. They can be tools that are used to enact political ends that we might not think of the courts as sort of being for in the sort of idea of courts as protectors of individual rights. And so it forces students to think more critically about what it means to be an impact litigator and the fact that it's not just some benign frame of social progress or social justice, that these are tools that are used in all sorts of ways. And particularly as a First Amendment litigator, I mean, First Amendment impact litigation is just as much about deregulation, if not more about that, than upholding individual speech rights. What is Citizens United but a corporate impact litigation case that was wildly successful? So this is sort of what I want students to think about in sort of puncturing the myth of the court as the safe space for individuals. I'll skip over Lucy White for a second and go to Amna Akbar's piece from just a few years ago. I think many of us have read that piece and found it really valuable in thinking through a contemporary example of how lawyers and clients can have really diverging frames for the social problems they're addressing, and also how the lawyers themselves, with our sort of little c conservative, backward-looking frame, are potentially not obstacles, or maybe even obstacles, but certainly not always aligned with what the communities that we represent or are working with are seeking. I see a question in the chat about activities that I ask students to engage in to drive home these ethical lessons. So I have actually done it less in the context of hypotheticals and more about discussion of our current cases. And so, for example, when we were talking about the Public Records Act litigation questions that we were dealing with the agency, I asked students point blank, like, how do you think about this as an ethical question when we might be thinking more generally about a social policy question when it comes to Public Records Act work? For example, the client was thinking about legal challenges, and some of the people we spoke to who work on Public Records Act work in our state expressed some mixed feelings about legal challenges because we thought it might reify some bad practices, or might, if we lost, it could give the agency more leeway to sort of deny access. I'm speaking very generally in order to avoid some confidentiality questions. And so the students had to really grapple with, okay, what happens if the client wants something that might be counterproductive for the larger movement for Public Records Act requests or for open government and transparency? And so I've done it less in terms of hypos and more in terms of like a mini case rounds discussion in the seminar, where students who are working on the case have to sort of talk through what they're thinking, and then the students who are not working on the case engage and sort of push back or give them a different frame in order to engage with the question. And then I may sort of jump in periodically to say, okay, well, what about this? Or, are we thinking about, who's the client in this perspective and what our obligations are, and how do we communicate that? So I've been lucky to not have to use hypos a ton for these questions, but I think in the future, that's one in which I would employ a question if we didn't have a live case talking about it. So another, issue that's come up, for example, is, and this relates, I think, really well with Amna Akbar's piece, has to do with the frame and the system that we can get results. So another hypo that I have posed and might pose in the future has to do with a client who wanted both a legal remedy from a government actor being allowed access to a public forum, as well as an apology, right? The client also felt that they had been wronged by the government actor, who was an individual legislator in this sense, and wanted an apology in addition to any kind of injunctive relief. And so the students were, of course, course, maybe not of course, but initially like, well, we can't get that. That's not like, how do we compel that? And I said, okay, well, let's back up. Why does the client want this? Like, what does it mean for a client to want an apology in addition to some legal remedy? And therefore, what do we do in talking with the client about it? Do we minimize it? Do we tell the client to not worry about that? Do we tell the client, no, like we can try to get that, but the real benefit here is going to be the injunction. And how do we sort of frame that discussion? Why do we feel the need to sort of tell the client, well, that's not possible? Because we don't know if it's possible or not. We have an assumption about it. And so this forces the students to think a little bit more critically about what it means to seek a remedy, what remedies clients might want, and why they might want those remedies. So what students are starting to engage with here is that the frame of the law can achieve some client goals, but it doesn't necessarily fit with everything that the client might want, particularly in an abstracted realm like impact work where we're trying to vindicate some sort of legal principle, or if the client envisions their goal in a way that's dissimilar or not consistent with the legal frame, like seeking an apology, which isn't necessarily something that the law is set up effectively to do. It also forces the client to think a little bit more, or the student to think a little bit more critically about what it means to be the lawyer representing the client, right? Sometimes students think of lawyer as sort of law explainer, right? And where the ethical rules help them be the sort of law explainer. And what we are always teaching them, and not just through ethics, but through cross-cultural lawyering, through client-centeredness, is that it's more complicated than that. And that's part of the reason that 2.1, lawyer as counselor, is a nice rule to emphasize this, that it talks about how lawyers can think about non-legal considerations. This is some of what I want students to think about when they're thinking about the limits of these and the issues involved with impact work, and what it means to be a lawyer and what the limits are there. One thing that I want to acknowledge too is that when I'm talking about ethics, I'm not necessarily sure if this is even ethics per se. When Allison and Layla and I were talking about doing this session, I think ethics was a nice inroad to this, but I think fundamentally we're talking to some degree more about lawyer-client relationships and whether ethics are a part of that. And part of the reason I frame it in terms of ethics is because as a legal ethics instructor, I think students get, I think it's more salient for them. I'm more trusted. And I also, have some paranoia and maybe ambivalence about my own role as a Plano faculty member, and particularly as a Plano faculty member in the South, as an Indian American person, as a gay person. I have some degree of concern about the ways in which talking about terms like social justice, public interest, cross-cultural lawyering are charged to a degree that may end up being either counterproductive with some students and or opening me up to critique or criticism from a larger community. And of course, in an age of paranoia, it's hard to know whether or not those concerns are justified or exaggerated. No one's ever accused me of being laid back. And so the idea that I might be overly sensitive to these things is certainly not far from my mind. I think also, it's really easy to sort of reify your own story about yourself in a specific environment. And one of the things that I've been really interested by is how, even in a few years of me being at Vanderbilt, that my students have changed, I think, in the ways in which they talk about issues. I mentioned today that I talked about judicial ethics, and I think that many of my students have a really deep skepticism of the Supreme Court, of judges, and they're probably getting it from me, but I don't think it started from me, right? I think that many of them came to the classroom with that idea. Now, maybe that they know that I'm some, caricature maybe as some sort of pinko commie, which is kind of hilarious for any law professor to be thought of as a pinko commie. But certainly one who works at Vanderbilt. So I think that it may be that I'm getting an audience that's maybe more receptive to my particular views on these things. It's sort of hard to say, but I think that, being sort of both critical and aware of one's own space on a faculty and also space within a larger legal community or within a large university is really important in framing these topics. And I find that ethics is a useful frame to get at some of the issues that I think many of us engage with by other names and through other ways. So I mentioned that I was going to skip over Lucy White, and I wanted to return to that before we hopefully spend some time with questions or larger discussion for the remaining period. So I'll go back to the slide which has the which has the citation. It's the bullet point 3, Lucy White's 1990 article, which I refer to as the Sunday Shoes article. So, I solicit a lot of feedback from my students, and one of the things that someone once said is that they wanted more readings like this in the seminar. And I told the class later, I was like, I don't know if there are any other readings like this. I really, really love this article, but I think, and I would love for people, if they can think of other readings like this, to put them in the chat. But I find it to be a really engaging, captivating story. And the reason I think it's so captivating for me is, like, one, as an English major, much of it is a narrative of her own experience representing a public benefits client in North Carolina in the 80s. And it just is really beautifully told as a story. Like, it reads like a short story. And so I think it's very engaging for me as a person who studied English. And then I think for students to think about a legal frame in a way that's quite different from the sort of very dry case readings that they may read, or the law review articles that they may read. In my ethics class, in addition to assigning secondary sources, I also assigned John Carreyrou's Bad Blood about Theranos, which similarly talks about really interesting ethical and lawyer representation questions through a very gripping narrative. And so I think it's a useful tool for students to grab onto, because it just presents the issues in more potentially dynamic ways. So in the article, Lucy White talks about representing a client who was involved in a public benefits dispute with the county because of some accounting error on the part of the county. But this is during the 80s, with a lot of really horrible racist welfare queen rhetoric. The client being Black is relevant to the story. The client being a woman with children is also relevant to the story. And so what her representation is trying to do is sort of figure out the best legal strategy to address the dispute, as well as one that might both respect the client's sort of dignity and rights in ways that are effective, but also potentially leading to a positive result. I won't spoil the end of the story, but it has a really surprising turn that Lucy White doesn't necessarily have a great handle on, or she sort of talks about her own multiple ways of reading the story and reading the ending in ways that I think students find, again, really generative and engaging. But the larger question that I want students to take away from the article is that, we're talking about a setting that's quite different from the First Amendment litigation, the constitutional, the very highbrow, very elite intellectual questions that we're dealing with in my clinic, as opposed to the sort of very, obvious and easy public benefits litigation. I'm being sarcastic here because I want students to understand that, they might think that we're dealing with very different concepts in different client settings, but in fact, there's a lot of relationship between what she's describing in her article and what we're seeing in our casework. I also think that the article does a really brilliant job of sort of casting and interrogating her own role in a legal system that ostensibly is supposed to be vindicating individual rights, but potentially is just reifying the social and political hierarchies that I believe law inevitably does, or at least does without a lot of pushback from people who want to see law do better and sort of erase as much hierarchical distributions as we can. And so I think that she does a great job in sort of interrogating her own positionality within the legal system. She also does a really great job in thinking about parallel universe explanations for why the client does what the client does, or what the reasons and justifications are. So it also helps students break through the sort of default assumptions they might have about the client. I mentioned my client who we were talking about their Public Records Act requests, thinking through why might the client be acting this way with the agency, or the client who wanted an apology, trying to get them to think not just, no, we can't get them an apology, but more, why might the client want the apology? And so her sort of investigation of the client modes and intentions is really helpful for students to jumpstart that for their own inquiry. And then I think the last thing that the article does really well that I'd like to focus on is how she realizes that she doesn't have all the answers, right? Fundamentally, the client has a different perspective on how to deal with the situation, or the client has different impulses or different goals that she may not know because she didn't ask, or she may never know, right? Because of her own role as an attorney and her client's role having a very different relationship with the legal system. And so the client's instincts in the article, I think, in many ways are really richer than her own, which is, I think, the moment of realization that makes the article really engaging for me, but I think also for students, when you realize that the sort of legal supremacy that we may have adopted or may be indoctrinated with within a law school can be challenged, can be interrogated, can be reformatted, right? And so Clinic as a site of that kind of reformulation is one in which I think students can really gain a lot of benefit. And so what we're, I think, trying to do, or at least what I'm trying to do, is try to get students to think more about their own assumptions, more about what they are coming to the table, assuming they're going to do, thinking they want to do, and how these readings can help them think a little bit more critically and to hear what their clients are saying, to really hear what it is, and to listen to what the client's trying to express. How is it that the lawyer-client frame can be defined, re-examined, modified in ways that force students and lawyers to be more attentive and more humble in front of their clients? And this goes to sort of, again, the limits of lawyering questions that I think about all the time, and I think probably as my own ambivalence about being a lawyer, being a public interest attorney, being a law professor, right? These roles that give me a lot of flexibility to be, I think, the lawyer that I want to be, but also really constrain me to acting within a specific kind of system in a specific kind of way as an advocate, as a social justice person. What is it that we as lawyers can do to solve social problems, and how we think about the lawyer-client relationship if we're skeptical of law's ability to solve those problems? This is, I think, a really abstract, high-level conversation that I like to lead to the end of the semester. And it's hard because I want to encourage students to think, to be excited about their work, about their career, but also to be critical, to be humble, and maybe also to be to open the door to them for the kind of reflection that I think really makes for the best lawyers, right? To think, okay, I'm not totally sure about my work with this client or why I'm doing this for the client. How do I engage with that? How do I talk to my colleagues, to my mentors, to my clients, to my collaborators in ways that are really effective in that kind of reflection, and setting them up for success, I think, in their career in order to be reflective attorneys, and to be the kinds of, hopefully, social justice, but at least progress-oriented attorneys that I want them to be. There's a few, as I end, there's a few articles that people have mentioned that I want to make sure I get onto the recording. One of which is by Dean Spade, called "For Those Considering Law School." Another, reflections on community lawyering, the struggle for Parcel C, and then a piece by Clark Cunningham called "Lawyer as Translator," all of which were suggestions that people had for additional readings that might get at some of the themes as the ones that I've mentioned today. So I'm going to stop there. I think we'll stop sharing, and then maybe if people have questions, they can put them in the chat, or I don't know, Layla, Allison, what the best way to do this is, but
if folks want to put questions in the chat, I think that'd be great. So we'll give you a minute to do so. Or suggestions, more suggestions as well.
this is what I get for not playing any ringers. Oh, this question from Sue. Do I have, from Student Chapter, do I have students visit these issues later to talk about them at the beginning and see how they've grown throughout the semester? So I haven't done that explicitly, but I think I probably will this semester, in part because the unit that I do on this is one that I'm doing 2 weeks from today. It better be 2 weeks from today, shit. Oh, am I not supposed to swear? So I think that when we get to assigning these specific readings, which my students have not yet read in the clinic seminar, we'll probably definitely harken back a little bit to the discussions we've had already in the class about these kinds of lawyer-client interaction questions. I think that in the reflection space, I have my students do 3 reflections about 300 to 500 words throughout the semester. And sometimes the students bring up these issues on their own. I do my mid-semester meetings with them actually later this week. And so sometimes on a more individualized basis, I ask them, what is it that you're thinking about with the lawyer-client relationship? How do you think about our work? And then particularly with the clients who are presenting these issues in a live way, in a non-hypothetical way, this is something I really hammer in supervision, as well as in the post-meeting debriefs where students are like, oh, I don't know why they want that. Like the students who were like, this client is gumming up the system. I was like, what do you mean by that? I sort of did my like Z-way lead in, like, tell me more. So I think that it's really rich to revisit them. And I think also for me as a First Amendment clinician, one thing I think about a lot is that almost none of my students are going to go into First Amendment litigation as a career. And so what is it that I want them to take away? And one of them is, I think, one of the things I want them to take away is this concept and is this question about what it means to be an attorney for a client and how you balance the different motivations and different goals that the client has. And so as a result, it's something that I try to pick up on as much as it arises with the clients. Also because it's a way for me to sort of work out my own ambivalences about these questions.
Great. I think we have time for maybe 1 or 2 more questions. And if there are people who can't chat because they on a phone or other device, I also think we can unmute. Oh, I see Julian Hill. You can unmute yourself.
Hey, good afternoon, everyone. So quick question that what your comments just sort of sparked for me. What are your thoughts, I guess maybe pros and cons of the idea around this being sort of a standing agenda item for supervision meetings? Just sort of like, hey, is this something that's come up? I know we do it sometimes in the context of team collaboration, but just wanted to get your thoughts on whether or not you think that would be valuable, maybe what some pros and cons might be. You're muted.
I think that's a really great idea and one that I might incorporate, which is that I have tended away from pretty structured supervision meetings, both for a few reasons, one of which is that students have tended to be a little resistant to it. But I think if there is kind of like an agenda that one uses in supervision, I think this is a thing that can be really valuable. Maybe going back to what I was saying in response to Sue Schechter's question, which is that this is a real skill and one that students have to grapple with learning in the clinic and ongoing in our own representation, and ones in which I also think about as an attorney, right? Because I've had clients that I've been annoyed with, right? And what do you do with that, right? I mean, I complain about it to my colleagues and then I have to do something with the annoyance, right? I can't just sit with the annoyance. And so I think it's a good skill to sort of emphasize as a skill, in part because it's something that is ongoing for many of us. And so I think that to the degree that setting it out as a specific topic to be discussed, in addition to sort of the follow-up from the interview or the case plan or the project plan, is, I think, a really great way to emphasize it as a skill. So I think that's a pro. I think the con might be that, especially in the beginning, this is one of those topics that I think is really a challenge for students to talk about in the abstract, because it can be very sort of amorphous. And so, I think teasing out the topic over time might lead to sort of more fruitful results in supervision or in other settings where you talk about it, because students start to understand what we mean when we talk about the complications of the lawyer-client relationship. So the only con that I have encountered is sometimes it can be a little bit hard for students to get their arms around it. You kind of have to sort of build it up a little bit more, as opposed to something like interviewing, which can be a little bit easier for them to understand, in part because many of us have done some kind of interviewing before we come to clinic. Oh, there's a question about thinking about more policy-focused questions versus impact. I think that's a really rich question, and actually one that I sometimes talk about with my clinical students in terms of my clinical life, distant memory though it is. So before I went into clinical teaching, I worked at a nonprofit doing policy and advocacy work. We didn't have individual clients. We used to say that our client was the public, right? The public interest. Also because we were a think tank funded by corporations, I would often sometimes tell my students that secretly our clients were Facebook and Google because they were paying for my salary indirectly. But we sort of talked more generally about public interest things. So I try to be a little bit forthcoming about what it means to be a public interest attorney in places where you might be funded by different kinds of groups. And so there, I think it's a real challenge to understand who is the client and what the client wants. How do we understand the client, right? We weren't doing surveys, we weren't doing focus groups. We just had intuitions about what the client wanted. And that can be really, that's not to say that those intuitions were wrong, but I think it really requires, for policy and advocacy focused attorneys, the ability to be really critical about your own motivations and why. And I think that's a skill that maybe students can grapple with. And so I think one thing that you might do either as a hypo for students is sort of say, like, you're trying to advance some kind of legislative agenda item or some kind of like public policy recommendation from a government agency or entity. And how do you come to formulation about that idea, right? How do you understand, you as a policy advocate, what your sort of thesis or proposal should be? I think is one way to sort of force students in the abstract as a hypo to think about it. And then as certain projects come up, I think that theme probably, it's hard, I think might come up in many different cases or matters that you and the clinic are working on. And so you can take that into the classroom and potentially adapt it for future semesters if you end up working on a different matter, talking about a specific hypo that maybe arose in the clinic in a prior term or a prior year. So anyway, I'll just close. I know that we're getting close to the hour, but it was a real really fun to sort of kick off the series and talk about these issues. As you can tell, I have a lot of sort of mixed feelings, mixed emotions about them. So I appreciate the captive audience for me to work through. And unlike my therapist, not $150 an hour. So that's also nice. I love talking about these things. And if people want to email me or talk later, please do feel free to reach out. I'll put my email in the chat, but it's gautam.hans@vanderbilt.edu. And I'm always happy to talk more about these very high level abstracted questions, and also concrete ones too, because I find it really helpful for my own learning and improvement as a clinical faculty member. And thank you again to Layla and to Allison for inviting me.
Thanks so much, Gautam, and thank you to everyone for joining us today. We have a really exciting lineup around the bend. Coming up in November, we have Teaching Justice Through Freedom Pedagogy with Narinda Hyatt, and we have Teaching Justice and Equity Through Externships with Alexi Freeman coming up in December, as well as a full lineup for the spring. So look forward to seeing you all then. Thanks again to Gautam and to Layla, and we will see you in November. Thanks, everybody.